our top story tonight. The Supreme Court hears oral arguments today in a landmark case regarding so-called gender-affirming care for minors. As you can see, the arguments drew protesters on both sides of the issue wanting to make their voices heard today. The justices are weighing a challenge to a law banning gender-affirming care for minors in Tennessee. At issue is whether the state's ban violates the Equal Protection Clause of the 14th Amendment. The ACLU attorney challenging the law says the ban leaves families terrified for the future, and access to this care is life-saving. Tennessee officials argue the law is designed to protect minors from risky, unproven medical interventions. The Tennessee law was signed by Governor Bill Lee last year. It prohibits all medical treatments intended to allow, quote, a minor to identify with or live as a purported identity inconsistent with the minor's sex. It also prohibits treating, quote, purported discomfort or distress from a discordance between the minor's sex and asserted identity. Chief Justice John Roberts questioned whether the issue is better left to state lawmakers.
Here, it seems to me that the medical issues are much more heavily involved than in many of the cases that you look to. And of course, we are not the best situated to address issues like that.
Meanwhile, Justice Brett Kavanaugh questioned how the challenge to Tennessee's law would affect transgender athletes in sports.
And I want to ask in particular about one thing. If you prevail here on the standard of review, what would that mean for women's and girls' sports in particular? Would transgender athletes have a constitutional right, as you see it, to play in women's and girls' sports, basketball, swimming, volleyball, track, et cetera, notwithstanding the competitive fairness and safety issues that have been vocally raised by some female athletes seen in the amicus brief of the many women athletes in this case?
No surprise, the case has gained nationwide attention and reaction from the faithful as well as church officials. The same month that Tennessee approved the ban, the U.S. Conference of Catholic Bishops weighed in on gender reassignment surgery, saying, quote, such interventions do not respect the fundamental order of the human person as an intrinsic unity of body and soul with a body that is sexually differentiated. Catholic healthcare services must not perform interventions, whether surgical or chemical, that aim to transform the sexual characteristics of a human body into those of the opposite sex or take part in the development of such procedures. And joining us now to talk more about all of this is Mary Rice Hasson, the Cato Burns Senior Fellow at the Ethics and Public Policy Center. She is also the director and co-founder of the Person and Identity Project. Mary, always so good to be with you. A lot to get to here, but first, what are your big takeaways from today's arguments?
Yeah, on the whole, I think it was a positive thing. I am cautiously optimistic. You can never predict exactly where the court is going to go. But I think it was interesting, some of the concerns that were raised. There was clearly a reluctance on the part of many of the justices for the court to wade into something that they saw as really medically unsettled. And so another interesting point was really the wide gulf in how the medical evidence was presented. And that wasn't the focus, but that was part of the discussion. And you heard two radically different presentations of that. And the attorneys were challenged on that as well.
Yeah, and you mentioned that. I know that Justice Neil Gorsuch really didn't weigh in on this today, but he did author a 2020 ruling protecting transgender people from workplace discrimination. Talk to us more about that, and why do you think maybe he was reluctant to weigh in?
Yeah, I think people were, or perhaps he was afraid that people were going to try to read the tea leaves if he said something or asked a particular question, that he was going to go one way or another. Because I think there is concern. The Bostock decision is very concerning for the substance, for the implications. It's being applied in ways that by its text, it was not supposed to be. So I think he was reticent, but Bostock did come up. It came up with the state or the U.S. government sort of trying to minimize, saying, well, you don't have to make this into a Bostock case, and being challenged on that to some degree. So I think it was interesting that the government, the U.S. government and the ACLU, in arguing against Tennessee's ban, they were trying to say, look, let's keep this simple. This is simply a matter of a state statute that is facially discriminatory on the basis of sex, and therefore the lower court should have applied a higher scrutiny, a higher level of scrutiny, if it implicates a sex classification. Whereas Tennessee was saying, no, 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 that's not the right way to look at this. This is about the medical purpose to which medicines might be put, and the state is perfectly within its power to regulate on the basis of public health and safety, and say it is not okay for a boy, for example, to want testosterone at the age of 10 just to get bigger muscles, whereas or put them on puberty suppression or something like that, whereas there are legitimate uses of this medicine for a different purpose. So it was, again, two different perceptions, where one was trying to say this is all about sex discrimination, and then the other saying, no, this is about the legitimate action of the state to regulate medical medicines for the protection of minors.
Yeah, almost out of time here, but some are saying that this could really be one of the most significant decisions of this term for the justices. Mary, can you talk to us more about that and the impact that this decision could have, not just in Tennessee, but on a broader scale? I know there are more than 20 states that have similar laws.
Sure. I think the ramifications are huge. I actually expect that the judges will probably just kick it back without trying to minimize what this is about and just keep it to standard of review. Justice Alito, one of the good things I thought about his questioning was he really raised the point about whether transgender status is a protected characteristic, and really pushed the ACLU attorney on that and said, is this immutable? Is it an immutable characteristic? And the attorney had to say no, backed off on that, which I think was a really important thing. So we'll see how it goes. It will have implications one way or another. And again, on the women's sports, the justices kept coming back to that, saying, if we kick this back, how is this going to affect the issue of women's sports? And, the U.S. government is trying to say, no, 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 this is just its own thing. But in reality, this is, you can't parse all of this. You either grant some sort of protected status or you don't, or you go and you look at the purpose of the statute and you say, this is not about sex discrimination or, quote, transgender status. This is simply about the state doing what it is well positioned to do, a legislature looking at the medical evidence and making a decision. And we are going to uphold that authority of the state. So I'm cautiously optimistic. You never know.
Yeah, very, very important case. Mary, thank you so much. Always a pleasure.
You're welcome.